Robert Kyagulanyi's legal team, lawyers for the respondents, President Yoweri Museveni, the Attorney General, and the Electoral Commission, together with the Solicitor General, came to the Supreme Court for the last hearing and verdict on the application by Kyagulanyi to withdraw his petition. The petitioner's lawyers and the respondents first had a chat before court started. Later, the 9 justices of the Supreme Court who constitute the bench, led by Chief Justice Alfonso Winyidolo, came to hear the final submissions on the application to withdraw the case. Medad Lubega Segona, Kyagulanyi's lawyer, was the first to submit by giving grounds as to why his application to withdraw the petition should be granted.
To find a pleasure in ordering each party to bear its costs. And the reason is that an election petition of this nature is a very important instrument of guaranteeing the safety of Ugandans in terms of democracy and rule of law.
First to respond on the matter was the first respondent, President Museveni's lawyer Edwin Karujire, who submitted saying that Kyagulanyi's withdrawal of the case should not be granted, basing on the falsehood submitted as evidence.
The sum of all this leads us to the conclusion that the petitioner has no evidence to support his petition, and the highest court of our land has been used as part of a political theatre, but not to resolve a legal grievance as the law envisages.
Karujire further argued that action should be taken against Kyagulanyi for the attacks he made on the Supreme Court by alleging that 3 justices on the bench were unfair and in cohort with President Museveni, the defendant.
Counsel Wameli was similarly on NTV, on the 23rd of February 2021, maligning this very court. The details and the affidavit of Mr. Oscar Chihika.
The allegations against the applicant are so grave in nature, to the extent that they are touching the relationship of a litigant and this court, a forum he chose to come to.
Chief Justice Owinyidolo had this to say.
The judiciary of Uganda, which I heard, we were never influenced by people who praise us or people who abuse us. You can abuse the Chief Justice, you can abuse the justices of the Supreme Court or the entire judiciary. But when you come before us and you're on the side of the law, we will protect you, the insult you have heaped on us notwithstanding.
Attorney General William Byaranga said he had considered that the withdrawal of the petition was not premised on any bargain or corrupt motives. However, Byaranga told court that Kyagulanyi had withdrawn the case after realizing that he had adduced weak evidence to show that there was rigging of the presidential election.
Because if you have a person who is not ready to pursue his petition on the grounds that he himself has decided that it is incapable of meeting the standards for the potential success, then he will be in a quagmire. He cannot continue because he knows he's going nowhere.
The alleged forgeries are a concoction by a person who is being strangled before this court and trying to look for evidence to extricate himself.
In his affidavit supporting his petition, Robert Kyagulanyi said that one of the reasons as to why he did not gather enough evidence in time was the fact that police and the army had surrounded his home, therefore he could not leave, and even other people wanted to access him were not allowed. He also added that his phone was disconnected, thus he was cut off from the rest of the world. The Attorney General submitted saying that Robert Kyagulanyi had access to one of his lawyers and also one of their close associates, that is Zake. But the same court asked the Attorney General to ensure that he quotes the law in support of his submission.
Does the law say that an intending petitioner, once they have contact to 1 or 2 people, that is sufficient? Is that the law? Can you cite any provisions
Well, I don't know
which you are relying on to make that assertion?
But I don't know whether a law gives a number.
Towards 1 p.m., Justice Stella Arach Amoko gave a brief ruling.
Considering that the respondents have no objection to the application for withdrawal, leave is hereby granted to the petitioner as read, and the petition stands withdrawn.
We intended to argue that the evidence is not there, is not sufficient, it is poor evidence, but fortunately they saw it before the judges even had an opportunity to rule on it and decided to withdraw the case.
Segona gave reasons as to why Kyagulanyi's petition should be withdrawn without costs.
I gave the reason that the procurement of those lawyers was illegal and that therefore they are not entitled to costs. But with respect to disbursements, I was quick to concede to Honorable Tashobia's fuel costs because he has traveled to court 3 times. I mean, from here to Electoral Commission is about 30,000. We can give a check to the Electoral Commission of 30,000 very quickly.
So what lessons has the petitioner learned from the process?
That grabbers love their loot.
For now, all the parties have to wait for the ruling from the justices on whether the petitioner should meet costs or not. There was an earlier submission by the petitioner that awarding costs will discourage the poor or less privileged from seeking justice or mediation in court. Sudil Yaruhanga, NTV.